Hello, I'm Gavin Elliot, and today I'm here to help you avoid some of the most common mistakes people make when creating their estate plan. As a Florida attorney, I see firsthand the consequences of poorly planned or hastily created estate documents. Estate planning is an essential tool for ensuring that your wishes are honored, your loved ones are protected, and your assets are distributed in a way that reflects your intentions. However, there are a number of DIY estate planning disasters that can lead to major headaches down the road. So, let's dive into 6 do-it-yourself estate planning disasters to avoid. First up, handwritten wills. Now, I know it might seem tempting to sit down and pen your final wishes on a piece of paper, but relying on a handwritten will, or what's legally called a holographic will, can be a huge risk. While some states accept these documents, Florida is not one of them. If your handwritten will isn't witnessed properly, it could be invalid. Even when handwritten wills are accepted, they are often challenged due to their informal nature. For example, a lack of a signature, unclear language, or alterations like crossouts can raise doubts about the document's authenticity, making it vulnerable to disputes in probate court. My advice? Skip the DIY approach and work with an attorney to draft a proper will that meets all legal requirements. Next, let's talk about drafting your own will. You may think it's easy to fill in the blanks on a pre-made template, but this can lead to mistakes that leave your family in a difficult situation. For example, what happens if you leave a specific asset, like your home, to someone, but you've sold the home by the time you pass away? Or what if you don't provide for alternate beneficiaries in case someone predeceases you? These are things that can easily be overlooked when you're not familiar with estate law. A skilled estate planning attorney can help you navigate these complexities, ensuring your wishes are clear and legally binding. Now let's talk about DIY will kits. Whether you find them in a store or online, these kits are rarely the right solution for an estate plan. They're designed for the most basic of needs, but everyone's situation is unique. What works for one person may not work for another, especially when dealing with complex assets or family dynamics. These kits may also fail to account for important state-specific laws here in Florida. Remember, estate planning isn't one size fits all. So while DIY kits can be tempting because they seem easy and inexpensive, they often lead to more trouble than they're worth. Another mistake I see is attempting to dispose of property outside your estate. If you own property in joint tenancy, like a bank account or real estate with right of survivorship, your interest automatically passes to the surviving co-owner when you die. You cannot override this in your will. Trying to do so will only lead to confusion. If you want to ensure your wishes are followed for this type of property, you'll need to make adjustments while you're alive. This is something an attorney can assist you with, ensuring your intentions are clear and enforceable. Now, executing your estate planning documents improperly can invalidate everything you've worked for. In Florida, for example, a will must be signed by you in front of 2 disinterested witnesses, people who won't benefit from your will. If your documents aren't signed and witnessed correctly, they may not be valid. For critical documents like powers of attorney or living wills, the requirements can vary, sometimes even needing a notary or additional witnesses. The bottom line is that improper execution can cause delays and disputes, undermining the purpose of your estate plan. A formal signing ceremony with an attorney can ensure that everything is executed correctly. And finally, amending your estate planning documents on your own can lead to disaster. Some people think they can just cross out a few lines or add in handwritten changes to their will, but this can invalidate the entire document. Changes to your will should be done through formal amendments, called codicils, or by creating a completely new will. It's essential that the revisions are done properly. Otherwise, you risk leaving your estate in limbo, potentially causing confusion or worse, legal battles. I hope this helps you understand just how important it is to take your estate planning seriously and avoid these common DIY pitfalls. A well-crafted estate plan is one of the greatest gifts you can leave your loved ones. But to ensure it's done right, you need the help of an experienced estate planning attorney. If you're ready to get started or have any questions, please don't hesitate to contact my office. We're here to guide you through every step of the process, ensuring your wishes are respected and your family is protected. Thank you for watching, and remember, when it comes to estate planning, don't go it alone.